Mark Chuparkoff, a Columbus attorney, resides in Dublin, Ohio, married, kid, successful law practice, looks the part, plays the part, speak to him, sounds the part. Great guy to have on your side. What you don't know, if you retained Mark, is that he's also got a dark side. Mark likes to drink, and that causes Mark some trouble sometimes. In 2017, Mark got himself a DUI, and it says here it's his first time. Well, if it's his first time he's been caught, it's definitely not his first time drinking. But here is, at 44, 45 years old, Mark has his first DUI. Maybe Mark was drinking because he got divorced and then got behind on child support payments, and then lost his law license. It was suspended in 2016. Take that back, 2015. It was reinstated January of 2016. But he could have been drinking because his law license was again suspended in August of 2016. Suspended because he had about 25 different clients complain about his professional behavior, and it was reviewed by the Board of Professional Conduct, and they produced this 60-page report, 60-page report upon their findings, and I think they included in their investigation 18 different customers. Let's take a look at what Mark Chuparkoff did to get his license suspended. Page 2 of the 60-page report says here that Mark had his license suspended on August 19th, 2016. This 60-page report with 18 clients, we could sit here for a good couple hours breaking down each one of these cases and what Mark did. But Mark mishandled money. Like in this case, what he did was he got a $2,500 retainer, and Mark should have put it into his escrow account, and he should have withdrawn it for earned fees when he completed a project, completed part of the case, or any third-party expenses that he had to advance. He, as it says, he did not. Instead, he immediately cashed the check and used the funds to pay for his personal or business expenses. In another case, Mark got a client a settlement in a personal injury case for $11,250, and out of that, Mark was supposed to pay medical bills, including a $3,664 lien from their insurer. He was supposed to pay the lien off with those funds. Well, Mark deposited the funds, paid the client a percentage, but he failed to pay the $3,664. So he paid himself, his third or whatever his percentage was, but then he also kept the money to pay the lien. Again, not using funds. I think that might be called stealing funds, actually, wouldn't it be? In another personal injury case, Mark failed to respond to discovery requests even after the court had issued multiple orders compelling him to do so. So he just didn't work on the customer or his client's case. Just did not work on it. In another case, his client was so upset with him, they asked for him to remove himself from the case and send back a copy file and then any unused portions of the retainer. To date, when this complaint was filed, Mark had failed to provide the client any detailed billing of his time, did not return any unearned retainer, and never sent the copy file. Just client said, "I don't want you representing me anymore," And Mark just said, "That's it, I'm done," and didn't close out the file at all. Did not provide any documentation of what he did, and just left the customer, the client, just hanging out there in the wind. Now, in this case, Mark took a $25,000 retainer, $25,000, and then he failed to respond to any discovery. So he took $25,000 as a retainer and failed to provide any discovery, and opposing counsel asked for the case to be dismissed. Now, $25,000, and he couldn't do anything. Now, here's a guy that was sent to prison for 9 years. He wanted to appeal his case. He went out and borrowed $1,500, retained Mark to handle his appeal, and Mark just disappeared on him. Just wouldn't get back to him. I would imagine if this guy's in prison already, and he's there for 9 years, $1,500 is quite a bit of money. And Mark takes it, no sympathy, no whatever. This guy's in jail, I don't care. He just took his money. Didn't respond. What a guy. So when Mark would take a retainer, what he would do is he was great at taking the retainer. He was great at making his hourly rate phenomenal for himself, because he would take the retainer, maybe file something, but he just wouldn't work. So his hourly rate had to be $3,500 an hour, $4,000 an hour, because he just didn't do any work. And what we're not really getting into here in all these cases is when Mark would take this money and then not do any work, he had to come up with a whole set of lies of what was going on. In other words, if somebody's filing a divorce, they expect the divorce to be filed. Well, nothing's happened. There's no filing. Or if they wanted a restraining order, or if the appeal process was supposed to begin, they're expecting to see something, get confirmation that it was done. And Mark had to tell a whole series of lies to keep these people at bay. And the depth of his line was phenomenal. The Akron Legal News here writes that the High Court decides the suspended lawyer is deemed a threat. He poses a substantial threat of serious harm to the public. Moreover, despite an ongoing investigation, Chuparkoff's misconduct has continued unabated. And I don't know if this is going to get caught in the video here or not. I'll try to squeeze this in. But at the bottom of this page it says, the memorandum from the High Court. The memorandum describes Chuparkoff's habits of misleading clients into thinking that he was working on their cases, and it was the clients who were holding up the process. In reality, his approach was to collect retainers from the clients and then not do any work. So Mark would not only take the retainer and not do the work, but then he would blame the client why nothing was happening. Blame them for what he was doing. Blame them why everything's going bad. That's where this guy's soul is. It's one thing to take money, then you feel bad about it. I would imagine you'd feel horrible about it. I don't know how you could talk to the people. But he just, not only does he take it, he doesn't do the work, but then he blames them. And that's what he did time and time and time again. Blamed the client for why their case was not progressing. The disciplinary counsel went on to say that that Mark Chuparkoff accessed the escrow account or his client's money to take care of various bills. His phone bill, his cable bills, child care expenses, car repair bill. He used his client's money that he did not complete any work on to pay for his own bills. And his financial problems were massive. Personal financial problems were massive, and he used his client's money to pay some of his bills. And they said that They were uncertain how many clients, Mark was quote unquote currently stringing along. And he failed to complete, and he has completely failed to cooperate in the disciplinary investigation. Just refused to cooperate. And he lied to the board. And the council, and they have spoke to several individuals in their investigation that said Mark has a problem with alcohol or gambling. So when he got in trouble by his professional board, what did he do? He lied to him, avoided him, and continued doing what he was doing. It wasn't contrite. It wasn't like, I want to make this right. No, he lied to him. He continued doing it. So didn't spend a lot of time in the individual cases breaking down what he did to clients, because we could be here forever. It was a 60-page report you can find online yourself. You can just Google Mark Chuparkoff disciplinary board, and I'll try to put a link here into the description of this video so you can just get to the PDF yourself if you want to. But the professional board, disciplinary board, said that he was very recalcitrant. He did not help out in the investigation, lied to him, and they told him that they interviewed people that said he had a drinking and gambling problem. That's Mark Chuparkoff. Mark even had a client who had a $75,000 settlement, which is great for the client, you would think, and it'd be a good, decent payday for Mark. If he's at a third, that's $25,000 plus expenses, whatever. But it's even better if you don't tell your client that there isn't any settlement and you keep the whole thing. That increases your percentage quite a bit. And that kind of goes to show you too, what is Mark thinking? How desperate is he? Because if you're taking $75,000, okay, so what he really took, he took $75,000, but $25,000 in theory was his. Well, he took $50,000. How far does he think he's going to get on $50,000? That's going to catch up to him. Previously we talked about him taking, $3,700. So he is nickel and diming his way. So, and any person with any type of intelligence knows that you are not going to go very far on $3,700 or $50,000. It's not going to take you too far. And every single one of those instances that you do that, you know that you have a client that is going to complain at some point in time or another. So, he was looking at a short-term fix. He had to know that it was going to be caught. But the problem, whatever his problem, whether it be drinking, whether it be gambling, whether it be drugs, whatever it was, he knew it was such a short-lived situation. He needed that money now, even though he knows he was creating a time bomb for himself in the very near future for a very small amount of money. I went to visit Mark. I wanted to see what he had to say for himself. Although I didn't make the complaint, I was not one of the cases. Mark handled my situation very, very similar to what he did with all these other people. I wanted to hear what he had to say for himself. And here's the worst part about all that he's done. As I sat there and talked to Mark, he started telling me again how I caused problems with my cases. How he didn't do anything wrong. Well, maybe I'm making a video here, so maybe he's right. But he said the same thing about all the other clients that he was found to have violated. Mark hasn't learned his lesson at all. From prison, sitting in prison. Lost a lot of weight because he's not drinking. He was as cocky as ever. As bold as ever. And he blamed everybody, including the judge. He didn't do anything wrong. It was the judge. It was the people. It was the law. It was the inability to explain. But he didn't do anything wrong. Not in my case, not in anybody else's cases. And he started attacking me after a few minutes. Mark hasn't learned anything. In fact, Mark bragged about how prison's really not that bad. Fits in. It's pretty good. And put on that smiley face that things were great for him. Mark wasn't punished enough. He didn't learn his lesson. I think he needs more of a timeout because he just doesn't have any remorse or take any responsibility for anything that he did. Now, when he gets out, he's not going to have a law license, but maybe he can get it back. But he hasn't learned his lesson yet. So if you run into this man, if you see him, he wants a job, wants to date you, if God forbid he gets his law license back, wants you to retain him, go look at his 60-page report. Go see what the disciplinary board said about him. See what he did to clients who suffered from things like medical malpractice and were treated wrong for years or were incarcerated and hoping for his help. See what he did to these people. Mark's, like the High Court said, Mark poses a threat to the general public. That's what the High Court said. And I heard with my own ears that he has no remorse at all. And he's going to be free soon. Mark Chuparkoff, a man to fear.